An amazing lunch can only be followed up by an amazing panel. After a lot of food for the stomach, we now give you a lot of food for thought. Our next panel is on the topic Developments Post-Amendments to the Arbitration Act. We have a great panel lined up for you. My name is Rahul Donde. I work at Levy Kaufman Kohler, a law firm based in Geneva, Switzerland. I'm on the steering committee of the Young MCIA. It is my privilege to introduce the next panel to you. As moderators for this panel, we have Ms. Pallavi Shroff, who is the managing partner of Shardul Amarchand Mangaldas, with over 34 years of extensive experience in litigation, arbitration, and competition law. We also have Mr. Nickolas Peacock, who is the head of the India arbitration practice of Herbert Smith Freehills, and he's based out of London. For our speakers, we have first Mr. Madhur Baya, who is the founding partner of Lex Arbitri, a firm specializing in international commercial arbitration. We also have Mr. Raj Panchmatia, who is a partner of the Dispute Resolution Group of Khaitan and Company. We have Mr. Sitesh Mukherjee, who is the partner of the Dispute Resolution Group at Trilegal. And finally, we have Taeko Suzuki, my apologies if the pronunciation is incorrect, who is an attorney at Nishimura and Asahi, a firm based out of Japan that has offices all over the world. Thank you. Over to the moderators. Thank you.
Thank you. Thank you very much, and welcome everybody to the post-lunch session. Firstly, I'm delighted to be here, and congratulations to the MCIA on a stellar first year and another very impressive conference. So you've heard the introductions. We have a very august panel here. I'm particularly privileged to be co-moderating the session with Mrs. Shroff. We're going to try and engage a discussion amongst the panel, and in doing so, we hope we will provoke some thoughts from the floor, which we will ask you to share with us later on in the session. Our aim will be to try and cover 4 topics under this general heading of developments post-amendments to the Arbitration Act. And I think for my part, what will be very interesting will be to get the views of our practitioners here from inside and outside India on what they view as the important changes and what's happening in practice. We know what the Act now looks like, but what's happening on the ground. So the 3 broad topics we're going to try and cover are going to be timelines, what's happening to timelines, arbitration appointments, grounds of challenge, and institutional arbitration. How is that developing? And I'm going to hand over to Mrs. Shroff, please, Pallavi, to kick off the first topic and introduce that.
So, huge changes made in the Arbitration Act in 2015. Very, very welcome changes. And I think all of these changes are very important and relevant to doing business in India. India is the fastest growing economy in South Asia and in probably most parts of the world if you look at it. How are we going to sustain and how are we going to attract investments and growth in India? Amongst the various factors that are important, such as the size of the market and educated population, I think even more important is the fact that there is a commitment to honor contracts. And if there is a dispute or a problem, there is effective dispute resolution mechanisms. Our courts are effective, but not as effective as an investor would like. We have independent courts, but the sheer number of cases that a judge has to handle can be overwhelming. And therefore, the alternate dispute resolution, I think, is very, very important. Also, international investors typically want to have a neutral venue for arbitration, neutral arbitrators, and therefore arbitration is quite an important. So how the arbitration progresses in a country could be one of the key factors in attracting investment and growth for any economy. And therefore, the changes that have come are very, very welcome. As our Chief Justice said this morning, they satisfy all the criteria that are typically relevant for any arbitration process in a country. Having said this, there are few critical stages through an arbitration process, and the first of which is the appointment of an arbitrator. Several changes have been brought in the new act with regard to the appointment of an arbitrator. And to kick off the debate, I would request Taeko to say a few words, and then we get into a discussion amongst the panelists. Over to you, Taeko.
Namaskar, and good afternoon, everyone. My name is Taeko Suzuki. Namaskar and good afternoon, everyone. My name is Taeko Suzuki, co-leader of the India practice team of Nishimura and Asahi, a Japanese law firm. I stationed in Mumbai and Bangalore in 2012 and 13. I'm now back in Tokyo, but I travel to India every 2 to 3 months. With regard to the appointment of the arbitrator, in my view, there are 3 key changes in the Amendment Act. First, the Amendment Act made the appointment of arbitrators an administrative decision rather than the judicial decision by the Supreme Court, High Court, or the institution designated by the High Court, while it was the Chief Justice or his designates who heard the matter before the amendment. This helped expediting the process of appointment of an arbitrator by reducing the burden of the Chief Justices, but also allowed to introduce the expertise and flexibility in allowing the arbitration institutions like the MCIA to play a role in the appointment process. Secondly, the Act provided a specific timeline. The Act provides that such an appointment should be endeavored to be disposed of expeditiously and within 60 days. The Act now sets out the specific timeline of 60 days, which is, in my view, is very unique in a comparative law standpoint. For example, the Arbitration Act in Japan, primarily based on ancestral model law, does not provide such specific timeline. This timeline sounded quite aggressive considering the Indian court practices where systematic delays unfortunately do exist. In one of the cases I co-counseled before the amendment, it took almost 1.5 years till my Japanese client received the decision by the Chief Justice of one of the High Court, adjudicating that there is no valid arbitration agreement, thus no appointment will be made, which was quite discouraging to my Japanese client for consuming such long time just in the process of appointment. Further, even in Japan, where the court proceedings does not face too much delays, it takes about 2 to 4 months on average for a court to render a decision on the issue of an appointment. However, along with the first key change I just discussed, this has helped in expediting the process of appointment in general, and the 60 days timeline has been proven to be practical in a case where the MCIA were designated to make the appointment of an arbitrator within 3 days, which Needy discussed in the beginning of the conference. Thirdly, the Amendment Act also provided the model fee schedule for courts may frame rules upon, while there were no such fee schedule in the old Act. This provides clarity and foreseeability with regard to the arbitrator fees, especially in ad hoc arbitrations. That was my introductory comments on this topic, and would like to have...
I think what I'm going to request, we're going to request is each of us will make a comment and we'll have more of a discussion amongst ourselves. So Sitesh, can we start with you giving your views or comments on?
One of the highlights of the changes in the appointment of arbitrators, I would think, is the conflict of interest provisions. And, you know, we were discussing among ourselves before this session, and people had different views on it. To my mind, the fact that India has so many ad hoc arbitration means that, you know, there aren't any institutions really supervising these arbitrations. So it therefore becomes necessary to ensure and go to great lengths to ensure, as the amendments do through the introduction of Schedule 5 and 6, that the arbitrators are completely independent. And the Chief Justice himself has, in a recent decision, as he was saying in the morning, set the tone by saying that if the person who is appointed as the arbitrator under the contract is not qualified or is disqualified because of conflict of interest, then even his appointee, who may be a very well-known jurist, his appointment would not stand. So I believe that that's a very strong message that the amendment sends out. It goes a long way in ensuring that the courts, when they look at the awards, have greater faith in the arbitral process.
I think, Madhur, you may have a slightly different view than Sitesh. Have we gone too far in trying to ensure independence and impartiality?
It's like this. I would, since I love automobiles, I would just relate it to automobiles. There is a concept of understeer and oversteer. So your car, if it is not turning as much as it should, it's an understeer, which is where we were. We were not turning the way everybody in the world was expecting us to. Suddenly we have overcorrected that. We have gone to the other extreme. And a slight turn can get you to bang into a wall now, because what you have done is you've over-legislated by bringing in all these guidelines into your statute, leaving it open to courts to interpret it, and as has happened in a few cases, I'm told. So when you leave it to a court, and you have 29 states in India and some 25 high courts in India, so you have an issue of 25 different interpretations coming in until one day the Supreme Court decides one way or the other. And that leads industry, investors, everybody into a tizzy as to what is the correct interpretation, whether this particular term in either Schedule 5 or Schedule 7 means X or Y or A or B. Should it go there? Should it not go there? And that's undesirable.
Yeah, so I quite agree with what Madhur is saying, but if we also look at what this has led to, we've seen various high courts passing contradictory judgments on appointment of arbitrators. While the guidelines were brought in with a view to streamline the process of appointing arbitrators and ensuring that there is no bias and things like that, some of the judgments have actually diluted these guidelines now by giving a statutory interpretation. Because, of course, as it has been brought in into the schedule, brought in into the act, it's become a statute. But were they actually meant to be interpreted in a manner like a statutory book? I thought these guidelines should have remained as the guidelines rather than bring in as a statute. This is creating a lot of problems. You're getting judgments from Punjab and Haryana High Court, judgments from Chennai High Court, which has actually diluted the entire process, where appointment of government nominees as arbitrators has been okayed. Of course, with some caveats, but they have still been okayed. So I don't think that was the intent. And the other point that I wish to make is what Taeko Suzuki made was regarding the fee schedule. Now, fee schedule was brought in with a view to have some benchmark for arbitrators to beyond which they could not go. But these fee schedules were to be accepted by each high court. Now, I don't think more than one or two high courts in India have accepted these fee schedules. So, so there is a lot of confusion regarding that. Second, there is also a confusion in the minds of the arbitrators whether these fee schedules are for ad hoc arbitrations, court-appointed arbitrations, or also for institutional arbitrations. The Act says that it won't be for institutional arbitrations, but there is also a confusion as regards whether the parties have not gone under Section 11, but have were appointed under an ad hoc arbitration, whether the fee schedules will apply, or will it apply only under Section 11 in court?
But practically, Raj, I believe, at least from our experience, when the arbitrator has not been appointed by the court, arbitrators obviously request the parties, and it's a polite request which the parties never decline, that the schedule is not to be followed and there is a different number which is always put down to parties. And I think that is not what the intention of the legislature was when they brought in this.
Also, I think we saw one extreme where in several cases, particularly in public sector enterprises, they would appoint the same judge for 10, 12, 14 arbitrations. And you know, it was almost the other side would never feel comfortable knowing that the same judge had been appointed 14, 15 times. How could you expect independence? So that was one extreme that we faced. Or the nominee, you know, 5 names were selected from a panel and you select one. Where was party autonomy in even appointing their own arbitrator? So there were a lot of problems to begin with. Was the solution in making this an absolutely cast iron thing written in the statute? Perhaps not. What could have been something else that could have been done? Could there have been more guidelines under the Act itself which had sort of a statutory flavor but not statutory itself? How do you make people come up and say, because a lot of the arbitrators were not even willing to come forth with a declaration or a disclosure as to how many arbitrations they were doing for the either party or being appointed by a law firm or a lawyer, you know, to do arbitrations. And that certainly sort of influences the way an arbitrator might think. So we were at one extreme, now we've gone to the other extreme. And I think it's always difficult to find the balance, but sometimes we feel having the other extreme is better than not having anything at all. Nick, what would be your perspective? You've always seen these as IBA guidelines, typically followed in international arbitrations. You always got a declaration or whatever. And most of the institutions require a declaration in any event without these guidelines being statutory.
Sure. I mean, this is a solution to the Indian situation. I think that's the point you make there, Pallavi. You're all entirely right. You come from a situation where arbitrators were being appointed in a manner that I don't see in any other jurisdiction, you know, clearly party-related arbitrators deciding cases in particular relation to PSUs. So you've got a situation where the use of these IBA guidelines, which by and large are adopted in most international commercial arbitrations in the major centres, you know, they're taking as read, they are the benchmark against which conflicts are judged. So I think you have to ask yourself, how do you make them applicable and, you know, if not mandatory, you've got to really put them into the minds of arbitrators taking appointments here. So, you know, there may be a number of ways it could have been done, and certainly I'm not aware of any other jurisdiction that's gone to the step of putting these IBA guidelines into its legislation itself. What will happen when they're updated? Well, we'll cross that bridge when we come to it, but the IBA moves quite slowly as well as the Indian Parliament. So there may be a coincidence of timing there. But it's unique, but let's see if it works. And it certainly, there was a solution that was needed, and let's see if this one does address the problem.
Yeah, and I think the only thing we can hope for is there's not so much interpretation or diluting of these guidelines by way of high court decisions, so as to bring in the problems back again, you know, through the back door. I think that's what we'd have to hope for at the moment. And the purpose is very important, and actually in a way they serve the purpose for which they are brought in. Though I think most of the, if you do the LCI or the ICC, all of them require a declaration of independence. But it's just not as prescriptive as our schedules are.
Yeah, it is the problem that we have with such huge numbers of ad hoc arbitration. I mean, if institutions were there to administer some of this stuff, these would be par for the course for those institutions. But in the Indian context, we won't have a way to bring them in unless, you know, they are, you know, legislated in some form or mandated in some form.
And I think it's not just the ad hoc issue, because you're certainly right. That is one of the reasons why you don't see these declarations of independence in debate in many other jurisdictions, because of course if you're going under institutional rules, you do what the institution asks you to do, including declarations about independence, and these days also time and availability to take on the case. And if you don't fill those in, you don't get the case. But there are other jurisdictions. I mean, Hong Kong's another jurisdiction that has a thriving ad hoc arbitration market, and indeed some industries in the UK as well. So I think it's partly ad hoc, but it's also partly, I think, where arbitration had got to in India and where the appointment process had got to that perhaps left the government feeling that something fairly dramatic, possibly oversteer, as you say, Madhur, had to be done.
I think all of you all have hit the nail on the head when you speak of this declaration, because two things come to mind immediately from an experience and practical standpoint. One was in an arbitration where the arbitrator did not make a disclosure. This was in August of 2016, well after the amendments had already been legislated. And we said, sorry, we have a problem. You haven't made your declaration. He says, I've said I'm impartial and independent. I said, that's not what the Act requires you to do. Please look at the 6th schedule. He refused to give that declaration, ultimately reiterating that I've already said I'm independent and impartial. That's one. The second was, I was in a situation where an appointment was offered as a sole arbitrator by an institution, and they sought a declaration of independence and impartiality. As luck would have it, one of the counsel for one of the parties was someone who had instructed me in a matter in the Supreme Court. I had to disclose that. The other party, and this is a multi-party public sector undertaking, multi-unit public sector undertaking, there was a dispute in relation to a particular unit of that PSU. I had no instructions against that unit. But I had two instructions which were still in correspondence. It had not gotten into a dispute per se, but I had instructions from clients against another unit of the same PSU. And I felt compelled to disclose it, should anyone have an issue with that. And I'm glad I did that, because obviously the institution came back and said, sorry, I think people have a problem with this. But do we go down to this minutiae in terms of disclosing every little thing that may someday give rise to an apprehension of lack of independence or impartiality is where things are going at.
So I just have one more point, and there's one more practical difficulty, as Madhur pointed out, and that is when we appoint an arbitrator, sometimes it's possible that these arbitrators have not maintained a record of number of arbitrations they have appeared in, or they have given written opinions to, or probably have been consulted with. It may be there for the recent 1 or 2 years, but over a period of years that they've given opinions, they've been appointed as arbitrators, and possibly the arbitrators may not have that record. Now, when you ask them to now give a declaration, and if they have not maintained the record, how good is that declaration?
No, it's also a question of how far back in time do you want to go. If you've done one piece of work for the client maybe 5 years ago, are you going to say that you are disqualified? It should not become a tool for misuse or to eliminate arbitrators who may be competent and who are nominated by the other side. So I think that also we have to be very careful, and it has to be very judiciously sort of played around with, used very carefully. It can be played around with very easily. I think that's the idea.
Right, thank you. Good starting topic, and there's more to be said on that, I think. But let's move on to the next topic, please. We're going to now deal with timelines and Section 29A, and this is the one that's got me excited, because we now have this Act, we have the amendments, this requirement for the award to be produced within 12 months of the tribunal to be appointed. We have a possible 6-month extension by agreement, an 18-month drop dead for the mandate of the tribunal, save with court approval for an extension, which again is pretty unique in global terms, possibly some more oversteer, Madhur might say. Let's find out. Madhur, can you give us your thoughts on this?
Sure. Thanks, Nick. I'm reminded of an Aesop's fable. Sorry, I'm digressing for a bit. There was this father and son and a donkey that they had, and they were walking past, and people in the village, they said different things at different times to the father and the son about how cruel they were that they were both riding the donkey, or how foolish they were that they were keeping the donkey on their backs and carrying the donkey. So this is what has happened actually with timelines. So our timeline, something which should be prescriptive, or our timelines which should not be prescriptive, this debate has raged on for 15 long years as we speak. The first time it came around in the 176th Law Commission report, went through that first draft of the amendments in 2003, where it was 1 year plus 1 year. Curiously, there the provision was that if the timeline is exceeded, you have crossed the 1 plus 1 year, then an application will be made to court. Court has the power to grant, an obligation to grant in that situation, to grant an extension. The arbitration would only be suspended, but the mandate would not terminate. Came a report in 2010 which said, that's not right, we should have no timelines. There's no one in the world who has timelines. Look at Singapore, UK, nobody has timelines. Revision 3, we come to 2015, where we again have timelines. And timelines, which is 12 months plus 6 months, and then thereafter in the hands of the court, which has consequences in terms of the mandate of the tribunal, consequences in terms of costs, consequences in terms of tribunal's fees. And interestingly, if there is a 20-month delay, the tribunal stands to get 0 fees, and they probably will have to refund the fees. I mean, that's how far it goes. The timelines, while it is one topic which is 29A, and there are within that subtopics in terms of the obligation of the court to dispose of an application within 60 days. I was talking to practitioners from various jurisdictions within the country, and I believe the one court which has been granting extensions of time is Delhi. Bombay yet does not have an application. There was a curious case before the Himachal High Court where one of the things which was said was that the timeline for an arbitration which predated, the commencement of the arbitration predated the amendment. The application was made to court that the arbitrator has taken more than a year. He has not rendered the award. His mandate has terminated. You, the court, now invoke your writ jurisdiction and give us some reliefs. So it was a little convoluted. Ultimately, the court said, look, it's something which is on the retrospective and prospective applicability, and we don't believe that it is retrospectively applicable, does not apply. Even if it did, the consequence of him having missed the timeline is, and if you don't consent to an extension is, that the provisions of section 15 are brought in, which means you can apply to the court for appointment of a substitute arbitrator, but that does not mean that things have ended, nothing can be done in the arbitration, you need to come to us under a writ jurisdiction. So there are timelines in other provisions as well. So obviously there are those in terms of the time that the court can take for disposal of a challenge under 34, the time within which an arbitration must be commenced after relief has been granted under section 9, the time within which the arbitrators obviously need to render their awards. There are multiple points, data points for timelines, and there are some which obtain under the Commercial Courts Act which tie in with the timelines under the Act. But from practical experience, I haven't seen of the 34 applications that we have filed, section 34 applications, I haven't seen any one of them getting disposed of in a period of 12 months, unless there is some different experience across the table.
Maybe the one odd case that gets disposed of for, unexplainable reasons, as I would put it. Everything just got expedited and you do through. But this timelines phase, if I can say two things about it, is fixing timelines. It sounds very attractive, but having to go to court is a danger. One, it increases the intervention of the court far too much than you want. Secondly, the 29A subsections provide that as for application for extension of time, the court shall endeavor to decide within 60 days. The word uses endeavor. There's no mandate. Given that workload, 60 days could well extend quite a lot beyond. So that's another danger of delay. In one of the 1940 cases that I had done, I filed an application for extension in one of the lower courts, and I got an extension, order of extension after 9 years, by which time the parties didn't want to pursue the arbitration. The key witnesses had gone. It was meaningless to get that application granted. So we don't want these kind of delays, and the fear exists because of past experiences. So while it looks very good, there is still an underlying sort of, fear that the courts will not be able to complete this in time. Not with anything else except with the sheer backlog of work that a judge has every morning, And so that was one comment. Which
again, when coming to timelines, and timelines are there in the various provisions, while it's good to provide for timelines, but what if you don't comply with the timelines? No consequences of default have been provided for within the Act. For instance, you have to appoint an arbitrator within 30 days, 60 days of your Section 9 order. But what happens if you don't? Why doesn't the Act provide that the reliefs will stand vacated? Automatically, people will start appointing arbitrators. That would help. Again, under 34, the provision has been made mandatory that the challenge will the courts will decide within a period of 1 year. Now it's a mandatory provision. It's not an endeavor. What happens if the court does not do it in 1 year? There are no answers to this. These things need to be looked at again, probably, and either amended it, corrected it. This is necessary, and therefore that's a.
Well, you're in good company in terms of wanting to look again at the amendments so soon, and obviously the Sri Krishna report asked to do just that. But let's assume this will stay in place for a little while. What's happening? What's the impact, Sitesh? What's happening to arbitrations on the ground?
So yeah, psychologically there is some degree of pressure of review by the courts, and we must keep in mind that a lot of the arbitrators are respected judges who have retired judges, and therefore they would be very keen themselves, and this is something that we have seen, to make sure that they try their best to comply with the timeline. But for the courts, I mean, in the event that the timeline is not complied with, an extension is genuinely required, and it could happen in many industries. For instance, in a construction contract that goes on for 4 or 5 years, sometimes it does take that amount of time, and you may have to go for extension after 18 months for another 6 months, genuine reasons. But the courts are being unnecessarily burdened with this whole exercise of extending time, looking into the reasons. I don't think the judicial system has the infrastructure to deal with this kind of cases in a short span of time that they are required to be dealt with. So oftentimes when you have these timelines and they are not followed, then it has the opposite effect of actually causing dismay among the people who want to rely upon it. So one must be careful about the timeline, and particularly important is the 1-year timeline for hearing objections. The courts should set the trend, I believe, and follow that timeline. It will go a long way in promoting the objective of some of the amendments. So yeah, the arbitrators are trying their best. The courts are also, in the Delhi High Court, the experience is that applications have been disposed of fairly quickly. The pressure of timelines and a breach of a rule plays upon the minds of people who are trained to uphold the law, which is a good thing. But yeah, this is where I think the Act also missed a opportunity to. The amendment should have, in my mind, been a template for institutionalizing arbitration. So, try and have the courts rely more on institutions like the MCIA, like the order that was passed by the Supreme Court. And MCIA responded with equal vigor by appointing an arbitrator in 72 hours. So if a timeline extension is required, why not allow one of the institutions to actually deal with that? These timelines are fine, but the administration of that, the court probably needs either specialized judges or the development of institutions like the MCIA to administer them.
Sorry, Sitesh. Sorry, Taeko.
I completely agree with what he said. Having timeline gives a lot of comfort for, especially for foreign investors, because we can now foresee when the dispute may finish. I also agree that institutional administration will help a lot.
I have one comment to make, and then I'll pass over. I think the speedy disposal of any arbitration is very, very important. Could we have achieved that by other measures rather than fixing this timeline of 18 months? And how we came upon 18 months and not 2 years, we don't know. I could well say that 2 months is better timeline and more realistic than 12 months or 18 months, coupled with lack of infrastructure, which Sitesh just mentioned. But I think measures like saying an arbitrator must commit that he has time for the matter and he will be available, having day-to-day hearings and not have 3 hearings in a day. You do 1 hearing in the morning, 1 hearing in the afternoon, and 1 hearing after 5 o'clock in the evening. So I have done arbitrations where I had a set of 3 arbitrators who did a cross-examination of witness action till about 4 o'clock, and 4 o'clock to 8 o'clock they did another arbitration. It just happened the very same 3 arbitrators were there in another arbitration. So they walked from one venue to the other, and we all sat down and did, for the next 4 hours, we did the arbitration in another matter. I mean, that's not the right way to do it. You have to spend adequate time to do these matters, and they have to be taken far more seriously than evening 5 o'clock to 7 o'clock. you know, and even the bar has to develop and accept that fact and not want to do everything at the same time. Go to court, do all your matters, and then go to do an arbitration.
But Pallavi, the biggest feature of the way we practice arbitration is the very same advocate, the very same client, the very same matter. If it's an arbitration seated in India, they will take a few sessions, and few can mean 10, 20 sessions cross-examining a witness. But if it's an arbitration seated, let's say in a London or a Singapore under any institutional framework or even ad hoc, they would be happy to do that in a period of 4 hours. Why? What changes? Other than the factor of transcription, which obviously is a very important tool for controlling time and costs, it is just the measure of saying, this is how it works here, we can do it at our ease and at our pace. And that's not on. It's for all stakeholders to control timeline. It's not just arbitrators, it's not just court, it's for us. Parties, lawyers, everybody has to contribute in that process for this to work. 12 months and 18 months, according to me, for 90% plus of the cases that most of us do is sufficient timeline. 18 for sure. There are very few cases which require more than 18 months, and globally 18 months is not a strange timeline. It's a pretty normal timeline to look at. One other aspect where this touches upon is the ease of doing business ranking. We are 164th on enforcing contracts largely because of the delays that we have in court and the delays we have in process. It's in our hands and it's in our interest to control and remedy that so that we go where we go. I mean, it doesn't probably make a difference to lawyers, but it does make a difference to our clients.
I think one other issue that we might want to all think about is, suppose the mandate is not extended for any reason at the end of the 18 months. God forbid, and it's not. What happens to that claim in arbitration? Is it saved by limitation, because the Limitation Act does not save time in an arbitration, or does it get dropped? How do we work through that?
So the immediate reaction is that there is this tension between 29A and the section 32. All that happens is, if the timeline is not extended and you have crossed your Lakshman Rekha of 18 months, sorry, Lakshman Rekha is a very Indian term, then the mandate of the tribunal falls and fails and falls away if it is not extended or the court refuses an extension, but the arbitration does not end. Therefore, your limitation issue will not really arise. Your arbitration is on foot, you will have a different tribunal. Whether you have to go back to an evidentiary stage, whether you have to go back to a predecessor stage, that only the new arbitration panel and the tribunal can tell. But yes, I don't think claims will be damaged.
On a lighter vein, you could use the argument of having pursued the wrong remedy for extension of time.
I think having come to this stage, I think very important, another aspect is the grounds of challenge. And huge amendments have been brought about in what can now be grounds of challenge. I'm going to let Sitesh start with his opening comments.
Yeah, we are still 164th in the world in terms of enforcing contracts. And if someone were to go by just that data, it would not be very encouraging. But the Act really has gone a long, long distance in ensuring that the mindset change takes place in terms of the grounds of challenge which have been a matter of debate in Indian courts. So I'll quickly elaborate on what those grounds of challenge are and how they have changed, and then we'll lead the discussion. So in terms of foreign awards, as well as international commercial arbitration seated in India, there was an ongoing debate on whether award which was rendered contrary to Indian law, in other words, patently illegal, could be a ground for interference by Indian courts. Now, initially, in the 90s, the law was quite clear that it said that it has to be something more than just being contrary to Indian law. That was the Renu Sagar judgment of 1994. But ONGC in 2004 changed all that, and the judgment went on to say that if an award was rendered contrary to an Indian statutory provision, then it was a patently illegal award. What that meant was basically every court faced with an award had to see whether the award was violating some statutory provision or not. It opened the floodgates for examination by court. And in the Indian context, a further scrutiny means more time, and the time is what Indian courts really don't have because of the huge pressure of the population and the pressure of the cases. So Niti Aayog recently came up with a paper which says that in India it takes 2,500 days to enforce an award. And partly the reason is, and at the same time you find that 80–90% of the awards actually get upheld. The reason for the entire delay is the burden on the courts. And by enhancing the grounds of challenge to include statutory violations, clearly the court took upon itself a task which was unnecessary. Then, of course, there was Fulchand and there was Sri Lal Mahal from the Supreme Court, which kind of clarified finally that it was not every award which was contrary to Indian law could be challenged. And finally, the amendments settled the issue, and it settled the issue very well from the point of view that it actually impacted the mindset of the judges, I would think, the way it is drafted. It clearly says that the award cannot be reviewed on merits, and it also excludes the ground of patent illegality in the case of foreign awards and international commercial arbitration awards seated in India. So both foreign awards and international commercial awards seated in India are at the same level so far as the scrutiny of the courts are concerned. And by taking out the ground of patently illegal test from the scrutiny, the legislature clearly sent a message that that's not an area that the court needs to get into. We still have to deal with that in the domestic award scene, where patently, if the award is held to be patently illegal or has to be scrutinized on that ground. Although the court has specifically, the legislature has specifically again said that merely because an award is contrary to law, it should not be set aside. The award should not be set aside by reappreciation of evidence. But that's something that still is there for domestic awards. And again, at some level, I was actually trying to find out why this distinction is there. And the Law Commission's report explains it very neatly. It says, under the current circumstances in India, it is probably necessary for Indian courts to exercise that level of supervision on domestic arbitration. Why? Clearly, the answer is more institution arbitration. The judges, the judicial system does not have enough confidence in the domestic arbitration process and therefore needs to do closer scrutiny. At least again here, if it's an institution arbitration, if it is an arbitration by institutions like the MCIA, the legislature should make an exception and eliminate this ground for patent illegality as well from domestic awards.
Before we get the stop sign, we have one more topic to deal with, and then we will have a further discussion, because there is a few points to discuss even on this, whether there is an impact on India becoming a hub for arbitration, and for us to encourage even foreign parties to do arbitrations in India because of the existence of the availability of the ground of patent illegality. So is that going to come in the way? But that's for a larger debate which we can have after. So Raj, can I ask you to have your opening remarks on the last sort of topic that we could touch on, which is institutional arbitration. How do we build upon large institutions and institutions like MCIA, and what role can they play in the whole conduct of arbitration as well as the growth of arbitration in India?
Yes, today by far we have MCIA is one of the leading institutions in India. In India, by and large, we've seen that there is ad hoc arbitration. 95% of the arbitration in India are ad hoc arbitrations. If we are able to swing even 5% of those into institutional arbitration, there will be enough arbitration for every institution in India. And it is very important that as a mindset change, people move from ad hoc arbitration to institutional arbitration. It has far too many benefits and advantages. We have standardized rules. We can get experts who have looked at the rules. The rules are tried, tested in different conditions. You have quality of arbitrators on their panel. The process is well defined. And I think that will be the key thing for any institution. Infrastructure, yes, is a very important process. We need government support in the institution building. We've seen SIAC, HKIAC, who have had complete government support when these institutions came up. And fortunately for MCIA, the state government has been supporting them completely. And therefore, it's very important that the governments support the institution. Fortunately, Supreme Court has also recently appointed MCIA as an appointing authority, which is a very positive move by the government itself and the state and the judiciary. Government has been given many recommendations where they have been suggested that government should give push to institutional arbitration, have well-defined institutions, well-defined rules, processes, have training for arbitrators, maybe accreditation for arbitrators, which will build in a good, credible institution. And if we have a good and a credible institution, I don't see why people should not move away from ad hoc to institutional arbitrations. And more the better, because there is enough arbitrations in India. You have more competing institutions standing up, no problem. But presently, I think MCIA is far, far ahead in time.
I'm reminded of a notification which the Department of Justice, Ministry of Law, Government of India issued on the 1st of September 2017, wherein they have said that 48% of all arbitrations and disputes in India are by government departments and government entities. There is a need for speeding up this process. There is a need for decluttering the judicial process. And they have said that you could go to various forms of alternative dispute resolution, including mediation, conciliation, arbitration, etc., etc. There is a list of about 17 institutions which offer these services, and I'm happy to say that MCIA is one of them. I had to make this point because this point hadn't been made since morning, and that's a very good sign. Credit to you guys.
Well, thank you very much. Some interesting topics there. We're going to open it up to the floor now, please. Just before we do, one comment from me. As Raj rightly said, arbitral institutions need support from government. Support, please, the existence, make sure we're here for the long haul. Of course, what they also need is hands-off from the government. Make sure we're here, but don't get involved in how we operate, how we decide decisions, how we appoint arbitrators. I'm very happy to say, as a council member of MCIA, that is very much the case in this institution, and let's hope it will be in others. So let's please open up to the floor. Any questions for the panel or comments you'd like to make, in particular, on how you're seeing these amendments operating in practice? And if you're from a court that is not Delhi or Bombay, be very interested to know whether any applications for extensions are being heard and what's happening to them. Yes, we have a question there. Please, into the microphone. Thank you.
Thanks very much. Josh Volkard from 4 New Square. I just had a question about the time limit and interim relief applications. My experience in the sort of ad hoc arbitrations that I've seen is that parties are still making applications to the tribunal for interim relief, but they're either quickly settling them or being encouraged by the tribunal to do so, obviously because of the pressure of time of the 12 months coming up. So I just wanted to ask whether that was also your experience and what effect that's having for the clients on the kind of immediate protection that they can get.
From a practical standpoint, we all as lawyers know that no client would settle only because of timeline. Clients are commercially minded, and if it is in their commerce for them to settle, then they will settle, time limit or no time limit. What is happening, and it has always happened even before the time limits were imposed, is that tribunals have always encouraged parties to resolve the disputes if they have a fair sense of where things are. And retired judges such as Justice Rebello, who's amongst us here right now, they have a fair sense of where the parties' cases really are. And we have seen tribunals encourage parties to resolve it at all stages, even before time limits and post time limits. But what this has done, time limits essentially is, A, it has widened the pool of arbitrators, if I may say so, because some very busy arbitrators are not able to take these mandates. And courts such as the Bombay High Court have been appointing young lawyers as the arbitrators. With them, obviously, a wider pool of arbitrators who is not judicially trained may have a different set of priorities, and they may sometimes encourage parties, but nobody does that unduly. So that's not the guiding force.
Sorry, to be clear, I'm not talking about settling the overall dispute. I'm talking about settling the interim application. So basically, by consent.
So Joshua, I think going to courts is always almost the first thing that parties need to do, because in most cases parties rush to court even before the arbitration invocation of the arbitration happens. And the minute you know there is a party, the tribunal is formed, which quite often takes 3 months. The courts today are very minded to immediately refer the matter to the tribunal, go before the tribunal. The order is now enforceable as if it were an order of the court. So I think there is a huge move to push toward. This had started earlier. In a number of matters, the courts would say, please go to the tribunal, it's now constituted, but now it's part of the statute. So we are seeing a lot of that.
Experience in the Indian courts in getting an interim order is far better than getting a final order, to answer your question. And so if you were to look for an interim order, it would be far quicker. Because the judges are also mindful that it takes time to resolve the issue finally because of the delays in the process. So they very keenly, they are very keen to balance the equities in the meantime. And they really do pay attention to it and try and make sure that the equities remain balanced during the pendency of the proceeding.
Okay, other questions? Yes, lady in the white top, please. No? Can we have the lady in the white top at the back there, please?
Thank you. Nick, it's me, Kritika.
Hi, Kritika. Sorry, the lights are very bright up here. I must apologize.
I just had a question on the timelines, actually, and the mandate of the arbitrators ending. It's actually a twofold question. So, A is, how likely do you think that the court is going to be taking into account the stage of the arbitration is in when that 18-month mandate ends? I.e., if the arbitration is close to a ending, and even if then the mandate is over technically within 18 months, do you think the courts are going to take practicalities into account to not order a rehearing and then allow that arbitrator to just continue? That's A. And B, even if that's not the case, how practical do you think the courts are going to be in ordering rehearings? Let's say if something is at the witness evidence stage or if something is at the document discovery stage, how practical do you think that the courts are going to be in not having new arbitrator or new arbitrators come and listen to the case once again?
So some of the judgments that have come out from the Delhi High Court have in fact had the similar issues, and where in fact the timeline was over, but parties did agree to get the timelines extended, keeping in mind the stage at which they were, and they had finished the evidence and only final hearings were left, and the courts did extend time. There have been issues, there have been applications which were just because of the complexity of the matter, courts have extended time. So they do, by and large, we've seen in those orders at least that the courts are extending time.
Probably they would, I think they would decide how much to extend the time. Do you need another 6 months? Can you do it in a shorter time? If it's only the award is still pending, they might do it in a shorter time. I think it is certainly a relevant factor.
Okay. More questions? Yes, please.
Yes. This is Ish Jain. I practice in Bombay High Court. So I would want to answer that question, that whether extensions have been granted in Bombay. So there are some 10 or 12 cases in the last few months where extensions were granted by the High Court. But as you guys rightly pointed out, that it's at the stage, they determine the stage at where the matter is reached, whether it's post-evidence or whether the witnesses of the plaintiff are completed, or what stage it is at. And depending on that, then the extensions have been granted for 6 months. But my question now is that do these timelines justify where these timelines are now used strategically by the respondents where they file a counterclaim 6 or 8 months after the initial arbitration is started. So do the timelines then get revised, or do the original timelines continue?
Good question. Someone can deal with that. Before they do, could you tell us how quickly the Bombay court has been dealing with these extension applications? Do you know?
I think on the very first date, so that's you file the extension application, you mention the matter, the third day the matter is listed and it's allowed.
Okay. So quick, there's no
Yes.
backlog or delay in deciding them?
No, I don't
Okay.
think so.
Well, that's interesting. Right, who wants to deal with the mischievous counterclaim halfway through a 12-month time-limited arbitration?
But it's the same arbitral process. Why should it reset the timelines? There's no question of timelines being reset.
But then how do you finish that in less than 6 months when the first one takes 18 months to finish?
The respondents have taken a tactical call. It's for them to manage how they want to manage. It's their, they are in the position of the claimant there. It's for them to manage their affairs. At the most, parties will go to 18 months from the start of appointment of the tribunal. And that's where it ends.
I suppose if you are the tribunal, you may well look at said party and ask them why they're doing it so late, and perhaps say to them, do you really want to bring this as a counterclaim when I've got limited time now to consider your case? You can always bring a separate action, of course, in your own arbitration. If you want to make it now, you might need to explain to me why you haven't made it before, but in any event, I'll do my best to hear it in the time that's allowed to me.
Or just rush through the whole process. If that's what the respondent wants, then rush through the process. But I don't think it says 18 months for claim and 18 months for counterclaim.
I understand
it
that,
doesn't
yes,
say.
absolutely.
Right, good
Thank
question. Any more from the room, please? Yes, please, sir. The gentleman with the reddish shirt on.
Sir, ever since this Amendment Act was passed, there have been conflicting judgments regarding the applicability of Amended Act to court proceedings, especially Section 34. So what is the correct judicial position as of now?
I think we'll have to wait for Supreme Court to decide that, because the courts are divided across the country.
Yeah, the next hearing in the Supreme Court is on the 21st of this month. Wait and watch. One doesn't know.
I think we have 1 minute left, so otherwise we're going to see the stop sign. I'm sorry, we may not be able to. One very, very quick question, and that's it. Otherwise, Neeti's sitting there literally growling at us. Yeah, last one. You, who, the last?
Thank you. This is Kushal Gandhi from CMS in London. I had 2 questions, but I'll restrict myself to one, which is, if you have the timeline issue of 12 or 18 months, how does that interact with the need for a fair trial for the parties? It sort of ties into this counterclaim question, which is, isn't there the risk that if you rush through an arbitration, that then exposes the tribunal to a challenge at a later stage?
Let me ask you a question on the other way around. Most arbitrations globally finish in 18 months without a question of there not being a fair trial. So I don't see why we in India cannot do it in 18 months with adequate time for arguments and everything else. It may mean there's a lot more burden on the tribunal to read the cases, to read the papers and appreciate it, but I think when push comes to shove, we can all do those in 18 months.
Sorry, if I got your name right, you're Kushal, right?
Yes.
Just remember, for every issue with timelines, there is this Formula 1 case which ended in 1 month and 2 days flat. Nobody had an issue with that. It was pleaded, evidence was led, hearings were conducted, award was rendered, ICC case.
Yeah. And let's not forget the commercial imperative and the clients who are largely absent from the room, sad to say, but those that are here, I suspect would agree that you would rather have good justice in 18 months than perfection in 20 years, even assuming you get there. So look, thank you very much for all your questions. Thank you to the esteemed panel and my co-moderator for this very interesting session.
Thank you everyone for being here, post-lunch and still wide awake. Thank you.
Yeah.